Well, good afternoon, everybody, and thanks for coming to the press conference. Want to start off by really congratulating Alyssa Peely from Alaska. You know, I don't know what it was this year, but a lot of folks tuned into the WNBA, especially during the playoffs. But I can recall Alyssa when she was at Diamond several years ago. And she was a phenomenal player then, and I think most of Alaska cheered when she went on to a Division I college, which if you saw her play in high school, you could tell that she was Division I, quote, material. And then she went down to USC, big college, right? California, everyone's heard of USC, and then transferred over to Utah, where she just did a phenomenal job. And I mean, I played basketball in a small college, but I watched her play a couple snippets here not too long ago, and she's just athletically gifted. And so when the WNBA draft occurred here just the other day, and she was picked number 8 in first round, I thought that was phenomenal. So I want to congratulate her. I wanted to congratulate her family. I'm sure they're proud, and they should be. And I want you to know, Alyssa, that a lot of Alaskans are going to be tuning in to the Minnesota Lynx games when possible here in the future, and that you know, your play, your sportsmanship, etc., is something that did not go unnoticed by Alaskans, and so we're cheering for you, we're rooting for you, rooting for your family, rooting for your friends, and the Minnesota Lynx will have a lot more folks tuning in from the Great White North. So with that, congratulations. We're going to move into talking about this court case that just occurred on Correspondence Homeschool, and we're going to break the press conference into 2 parts. The first part, we're going to talk about the legal aspects of it. And we're going to have Attorney General Treg Taylor come up, and he's got online in Juneau Corey Mills, Assistant Attorney General. But we're going to talk about what we believe has occurred, where we think this may go, and what are going to be some of the actions by the administration regarding the decision that was made. And then we're going to stop it and allow folks to ask questions on the legal aspects. Then once the questions are done on the legal aspects, we'll go into my thoughts on what's occurred, the impacts on education, and it is going to be somewhat speculative where this is going to go because there's still more to be done with regard to a higher court. And so I'm going to ask Treg to come over. He's behind me here. I'm going to ask Treg to step up to the mic and just go through the process by which this decision was rendered and what the interpretation is at this stage of the game of law on that decision, and what are some of the actions that we're contemplating from a legal perspective.
Thank you, Governor. I want to start by framing what this case is and what it is not about. The lawsuit that was brought challenged our correspondence school allotment program as is laid out in our statutes. The lawsuit did not challenge a particular school district or the way the allotments were distributed. That would be what we call as an as-applied challenge. Instead, NEA challenged the entire allotment program as unconstitutional, a program that the state was engaged in well before 2014 when it was put into statute.
NEA challenged the entire allotment program as unconstitutional.
Folks on the phone, if you can please make sure that your phone is muted. Thank you.
It remains our position that the statutes are constitutional and that the long-standing correspondence school program should be upheld on its face. What did the Superior Court find in its decision? Well, one, the court said that AS 1403 300 through 310 must be struck down as unconstitutional. They did that in the entirety of those statutes. These 2 statutes provide the framework for all correspondence school programs in Alaska, so it goes far beyond just the allotments themselves. The decision represents a complete lack of understanding on how a correspondence school works. Correspondence school is public school. It is administrated by school districts. The students work under a public school teacher, and the students receive a school district diploma upon graduation. Let me repeat, the correspondence program is a public education. The court also said Here, the plain text of the statutes clearly authorizes purchasing educational services and materials from private organizations with public funds, in direct contravention of the direct benefit prohibition of the Alaska Constitution. What needs to be noted here is that the use of the term private organizations instead of what the Alaska Constitution says, which is private educational institutions. And also, the purchasing of materials is also included in what is unconstitutional. Private organizations and materials can include things like music lessons, a dance studio, a textbook company, the food vendors that serve food at the school. The list goes on and on. This also flies in the face of correspondence programs that have been around since the territorial days and remained after statehood. In light of the vague, broad nature of the court's reasoning, it is very difficult to determine what type of program would actually be permitted under this decision, where, in fact, it draws into question spending that has taken place in public schools for decades. Therefore, we will appeal the decision and will be asking that this court decision not go into effect through the period of the appeal. Where we are now is that the NEA has asked and filed a motion to stay the decision until June 30th, 2024. We think that is not enough. This coming Monday, we will file our response to the plaintiff's request and ask for a stay to go out longer until at least we have a final decision from the Alaska Supreme Court. I don't know that I have ever heard of a plaintiff wanting to stay a decision that came out in their favor. Clearly, the NEA, who asked for this result, recognizes the magnitude and devastating consequences of this decision to Alaskan students and to families. If the Superior Court doesn't grant the stay in the way we want, we'll ask the Alaska Supreme Court to grant it. We will also be seeking a quick resolution through an expedited decision on the stay motions and an expedited appeal. Our goal is to bring as much certainty to families, school districts, and education vendors as quickly as possible by getting this decision halted and seeking review at the state's highest court. Thank you.
All right, so we're going to start with questions here in the room. Starting first with Iris Daniels, the Anchorage Daily News.
Thank you. Attorney General, yesterday we heard an interpretation of this decision from Senator Wielechowski that's a little bit different from what you just described. It sounds like his interpretation of the decision is that it may not have significant impact on students in correspondence programs that don't use the allotments directly as tuition payment in private schools, that use it maybe as it has been used for many decades in Alaska for purchasing curriculum and things like that. I'm wondering if you can clarify if your interpretation is in fact different from that and if you hope to preserve families' abilities to use allotments directly to pay for private school tuition.
With all due respect to the senator, I disagree with his interpretation of this. If you read this decision, and it's a short decision, it is extremely broad in what it encompasses, and the legal arguments that were used in this decision then now could be used against any spending a school district does outside of the public entity, right? What about what about textbooks? What about all these other things that school districts regularly engage in with private organizations? And so if you use the logic in this decision and you apply it across the board, this could have a massive effect on how school districts operate in the state.
We're next go to Eric Stone with Alaska Public Media.
Hi there, Eric Stone, Alaska Public Media. So in speaking with the Institute for Justice plaintiffs, they alluded to some possible federal causes of action as far as the Blaine Amendment. I'm not sure if you're familiar with that, but basically the idea is that if you restrict spending on religious institutions, on religious schooling, that violates the ability of parents to sort of choose the education for their child. Do you guys see, if the Alaska Supreme Court decision doesn't go your way, do you expect to appeal this to the U.S. Supreme Court?
Well, we'll see what the Alaska Supreme Court does with it. At this point, we're keeping all of our legal arguments on the table.
All right, we're going to go online now to Mark Sabatini with the Juneau Empire.
Hi, can you hear me?
Yes, go ahead, Mark. Mark.
Hello? Okay. I guess my question, since we're talking about the technical aspect, is a fairly simple one. Sorry, I'm dealing with two different audio streams. One's delayed. But my question essentially is, the governor has previously said, especially when this law passed, that a constitutional amendment is needed to have this comply with the language prohibiting funds going towards religious or private schools. That amendment obviously doesn't exist. So based on that, what has changed in 10 years that can justify your motion to appeal this that doesn't violate that part of the Constitution?
I think that's a mischaracterization of the record. I think if you look at the full record in the legislature, when the governor was a senator, you'll find that that is a misrepresentation of what occurred, and also a misrepresentation of what was presented at that time and what actually became law.
All right, next we're going to go to Carter
Okay.
DeJong. Next with Carter DeJong with the Fairbanks Daily News Miner.
Yeah, thank you, Carter, with the News Miner. I guess I'm just wondering, for the Attorney General, when do you have any idea of when you can expect a decision as far as an appeal, whether that's this Alaska Supreme Court or whoever?
To a certain extent, that's up to the courts and how fast they move on this. We've seen them move extremely quickly when we have sort of election issues that come up. We are going to seek an expedited hearing and an expedited decision on this. So, to a certain extent, it's in the court's wheelhouse for determining time frame.
All right, next we're going to move to James
Thank you.
Brooks with the Alaska Beacon.
Hello, am I coming through all right?
Yes,
Yep.
we can hear you, James.
Great. A.G. Taylor, I'm actually kind of surprised that you're the one talking to us rather than Corey. I thought you were conflicted out on this issue because your family personally benefits from this. Could you talk a little bit about your involvement or not in this issue?
Yeah, I'll be happy to do that. So we made a decision within the Department of Law that I would not participate in a memorandum that was outlining sort of the legal framework for correspondence schools at the time. In abundance of caution, decided to withhold my ability to work on that project. Since that time, the situation with my kids' schooling has changed significantly, and we actually went to the length of having outside counsel look at that conflict and determining that I don't have a conflict and can fully participate in this litigation.
All right, thanks, James. Next, we'll move on
Could
to
you explain a little bit about how that was resolved?
Only that there is no conflict.
All right, moving on, we'll go to Jazz Garrett with KINY News of the North.
Can you hear me okay?
Yes, we can. Go ahead.
I wanted to ask, I saw that the plaintiffs had brought forward this suit after noting an uptick in private schools advertising that parents could use these correspondence school allotments to pay for classes or tuition. And could you give a comment on that and how that relates to the indirect benefit or direct benefit?
Yeah, happy to. Again, Correspondence School Program is a public education administered by public school districts, public school teachers with a public diploma. I think if you look through our briefing that has already occurred in this manner, you can get the specifics of that argument. And as we appeal this, you'll see that argument once again laid out. But I don't want to lay out legal arguments here in front of the press today, given that we do have a current litigation going on.
All right, next we're going to go to Becky Bohr with the Associated Press.
Thank you. Attorney General Taylor, it was mentioned yesterday in the Senate Majority News Conference the potential for deed to right emergency regulations going back perhaps to pre-2014. Do you see a need for emergency regulations to be in place while this case plays out?
I'm going to defer that question to the governor as he'll talk policy. I know the governor has deep concerns with this decision and is prepared to take whatever necessary action in order to alleviate the burden on these families and these students. And we're talking about 24,000, over 24,000 if you include everyone that participates in those correspondence courses. So that's a significant effect on Alaska families in a real hurry. So I'll let the governor address that question.
Yeah, so if there's any more questions regarding the legality, whether it's a question on stays, whether it's a question on taking it to the state Supreme Court, the Attorney General can answer that. If we're going to morph into the policy part, we can start that now. So is there any other questions on,
3 more folks.
if it's legality, yeah?
Yes. So Margie, if you have a question for the Attorney General, go ahead. Margie Bowman with the Cordova Times. All right, moving on, Jeff Landfield with the Alaska Landmine. If you have a question for the Attorney General.
I'm sorry, it's Margie. I was muted.
Okay, go ahead, Margie.
I'm just wondering about the amount of time and emphasis being put on this issue while there are schools all over the state waiting to see if the amount per student is going to be raised or not. Most of the school districts in the state
Legal question or policy question?
rely on the funding per student, and they're in pretty dire straits. Cordova, for example, has said that if they don't get a reasonable allocation, they're going to be $1.5 million in the hole in their education funding. They are counting on a raise in the allocation per student, and all the emphasis seems to be right now on getting more money for this program instead of that. Can the governor please comment on that?
So
Thank
any
you.
more questions for the Attorney General, because I'll handle all these other questions.
Yes, Margie, we'll come back to this later on in the news conference. I want to see if Jeff Landfield with the Alaska Landmine has a question on the legal issues for this for the Attorney General. Jeff, are you there?
Yeah, I'm here. My question is more of a policy question on the
Okay, so we'll come back.
potential constitutional things.
And Steve Kirch with Alaska's News Source, do you have a question on the legal specifics of this case? All right,
Okay, no, I appreciate that. And we'll,
Yeah.
Yeah, can you hear me okay? Yes, go ahead, Steve.
Yeah, I just want to ask a question to the Attorney General. It seemed like this case took a long time to come to light. Probably about 10 years. Why? What exactly legal hoops did this go through where it took so long? To get to this point.
I'm not sure I understand the question. I think this case has moved faster than most people expected to do. I don't think anybody expected the judge to rule the way he did and the manner he did and as quickly as he did. And so if that answers your question, I think things have been moving very quickly. If you're talking about the length of the correspondence program, like I said before in my statements, this has been around since before statehood, and it was codified into statute, when the governor was senator. So it's been that number of years that statute has stood on the books and was just recently challenged, obviously.
okay, thanks, Attorney General. So we're going to get into the policy issues and the hypotheticals. And generally, we don't deal with hypotheticals, except that in this case, you have a ruling by a Superior Court judge that we're dealing with now. There's discussions of stays. There will be discussions of taking this to the Alaska Supreme Court. There also may be implications that it goes to the U.S. Supreme Court, depending upon the outcomes, which we don't know yet, of what the state Supreme Court may argue. And so we're dealing with an answer. Actually, I answered that question that was just presented to the AG. Why did it take 10 years for a case to come? I don't have the answer to that, other than We didn't bring the case. This case was brought by NEA and others against the state of Alaska, and I can only speculate as to why it is happening now. And part of the reason it's happening now is we've gone from a few thousand kids in the homeschool programs to 24,000 and growing. And that's a significant proportion of our public school students. And so, in my opinion, and I'm going to speculate, in my opinion, the reason that case is happening now is the same discussion we're having with charter schools. And that is, in the end, is it the state of Alaska, the people of Alaska, are they going to determine what our educational system looks like, or is it going to be NEA or the School Boards Association? So really this is a fight about control. There's no doubt about it. It'll be masked as a religious direct benefit question. But in the end, it's really about who's going to control the educational programs for the state of Alaska and its kids, and who's going to, likewise, who's going to control how charter schools are formed in the state of Alaska. That's what really this is about. Margie asked the question on funding, and I should start taking count. I've probably up to about 65 times I responded to the question. There will be more funding in education this year. There will be. There will be more funding. But really the question is, what is the educational system of Alaska going to look like? Because, and Treg, you can hop in any time you want, part of the interpretation of the ruling that just occurred is that the homeschool and correspondence laws are thrown out. In other words, programs are gone, potentially. And so we're trying to weed through exactly what the decision actually means. Part of the decision, part of the language in the decision was that the legislature may have to look at constitutional considerations. Well, if that's the case, then statutory considerations won't remedy the situation. That's part of the problem. So we're looking at a whole host of hypotheticals and possibilities that we're gearing up for. If this goes to the if this goes to the state Supreme Court, which we believe it's going to, well, hopefully we get a stay. And as Treg said, it's unprecedented for a plaintiff to want to stay the decision that would appear on the surface to be what they wanted. But I think what occurred here was this decision was so vast, so overreaching. And again, some, when they view the decision, believe that the homeschool and correspondence laws were thrown out, which would disenfranchise 24,000 kids, 24,000 kids, 1,000 plus vendors, countless families, 265, I think, teachers that directly deal with homeschool. And so there's a lot of clarification that needs to occur here. When I first became a senator in my freshman year, I ran a constitutional amendment that would allow public money to go to private educational institutions. That constitutional amendment failed in the legislature. There wasn't support for it. That's part of the process, the way it is. Years later is when I had a bill, SB 89. Wes Keller had a bill, and I believe it was either 151 or 156, I believe. He was in the House at the time, had to do with education. And basically, my portion of the bill that was rolled into Wes Keller, Representative Keller's bill, basically said that we're not going to discriminate against vendors in a public education homeschool program. That if you wanted to buy a Latin course from, let's say, Monroe Catholic for the purpose to underwrite your public education, because keep in mind, there's two types of homeschooling in Alaska. There's private, divorced from public. Those individuals and those families don't have to sign up with the state. They don't ask for state aid. They are totally on their own. Alaska, from that respect or perspective, probably has the freest non-public homeschooling laws in the country. Then there's public homeschooling, in which it is a public school run by publicly certified teachers, run by school districts that are public. So the purpose of the public homeschools are a public education by public school districts using public money for publicly enrolled kids with a public ILP for a public outcome. They are 100% public schools. The issue apparently is, in part of the development of the ILP, the Individual Learning Plan, when a family goes and talks with the public school teacher, that there are vendors now, and there always has been vendors, and I'll make that clear. There have been vendors associated with religious outfits for decades and decades and decades. Brigham Young University is an example. You've had multiple court cases going back to 1961, I think it was Quinton versus Fairbanks, which was a school bus issue about a little girl that was being picked up by a public-funded school bus and then dropped off at her private school. In 1976, there was a court case called Sheldon Jackson, in which the Attorney General at the time brought suit against a scholarship program that was put in place by the legislature, claiming that Sheldon Jackson was a private university, a private college, and therefore public money should not go to it. Where I'm going with this is when you look at those court cases, and we'll see what our state Supreme Court does, and I'm not trying to scare people or worry people, but if the interpretation of the Superior Court to some degree is carried over to the to the Alaska Supreme Court, you may not just see spending to purchase courses from religious vendors. Again, an example, if you want to buy a Latin course from, let's say, Monroe Catholic, and I'm just making this up, folks, the ILP would underwrite that and purchase the course for the kid, the child, for their public education. If this ruling is as broad as some people think, and the entire homeschool correspondence laws are basically off the books now, this may implicate everything from spending for contractors, non-public entities that supply services to school districts. For example, you have an outfit that's been around forever called Sylvan. School districts oftentimes use Sylvan for tutoring. That may be gone. So in essence, we don't know yet exactly where this is going to go, but if it is as broad as some may think, and I think this is one of the reasons why the plaintiffs rushed to get a stay, because they saw what had happened here, it may not be able to be remedied by a statute. That's the problem. And so if private and everything that's non-public, if it's private and or religious, non-public is thrown out, you're going to see, I think, a situation in Alaska which is unprecedented, to be perfectly honest with you. So we don't know. So we're preparing as an administration, and we'll be having conversations with legislators. We're preparing everything from being prepared to talk to folks about a constitutional amendment, depending upon the outcomes in the Alaska Supreme Court, to looking at an education dividend, because we have a permanent fund dividend. We don't ask people how they spend their PFD. For all we know, we may have families that spend their thousands of dollars in their collective PFDs on their churches. We don't ask what they do or how they spend their money. So we may be looking at an educational dividend to assist people. We may be looking at something with the post-secondary scholarship commission, scholarships in the post-secondary commission, to look at K-14 scholarships. Because right now, again, if this is as broad and deep as some may think, the whole post-secondary concept is turned upside down on its head. Because a lot of money there for scholarships go to private institutions, go to non-public institutions in order to educate people. So in the state of Alaska, like most of the country, you don't have a simple, just pure public only, because you're buying services and equipment and goods from private vendors to underwrite the public education. And that's what this homeschool process was and is. Public school, public education for 24,000 kids. Want to say something else on this issue. There is a mistaken belief, and I've heard it by a couple, that no big deal. The 24,000 kids are welcome back in our neighborhood schools. I'm totally surprised, shocked at the premise that they're just going to line up and go to our neighborhood schools. First of all, there were 24,000 reasons why they either didn't or could not go to our neighborhood schools. Medical issues, family situations. Some of them may have been athletes. Some of them may have been involved in other activities that just prohibit them from going to a neighborhood school. That's not going to happen. If the extreme end result that some people fear occurs with our Alaska Supreme Court and everything is thrown out, you're not going to see 24,000 kids going back to the neighborhood schools. The whole idea of the educational system in Alaska, the whole idea that I and many others talked about for decades as a public school teacher, as a superintendent was, let's broaden the opportunities for kids as much as possible. And what's happened in Alaska is something that's happened, I don't think, anywhere else in the country. So I got to do another clarification here because it's important for people to understand. A voucher is when the state sends public money directly to a private school for tuition to basically save a spot for a kid to go to a private school. That's not public education. That's a voucher going straight to the private school. What we have in our homeschools is purely public education for a public purpose. That's the allotment system to help underwrite the ILP, which the teacher, certified teacher, works with the parent in our school districts to come up with a menu of courses to meet the kids' needs. Many of those are private vendors, welding outfits, heavy equipment outfits, dance studios, art studios, music, you name it. They're all private. Under the extreme possibility that this thing is totally thrown out, they're done. So over 1,000 vendors are finished. The 24,000 kids, again, are not necessarily going to line up to walk into the neighborhood schools. We estimate this is roughly about $120 million is what we're looking at. And then the question is, if it is thrown out, what do you do with the child that's 100 miles from the nearest road? And they're trying to get an education. Maybe they're in a remote lodge, mining camp. Can they get state money to help buy private educational services if this is thrown out? Apparently they can't. So we don't know where it's going to go. We don't know what the Supreme Court is going to do. But there was a question, I think, that alluded to another issue, is if the state Supreme Court just strikes the ability to purchase materials or coursework from religious vendors, there's a very good chance that'll be taken to the U.S. Supreme Court to be challenged there by interveners, by others that are watching this right now. And so, to be honest with you, not sure where it's going to go. We're preparing 3-4 different responses, everything from a constitutional amendment and discussion with the legislatures, which that will start, to an educational dividend, to talking with the post-secondary commission, and maybe some other approaches we haven't thought about to ensure that these kids are educated. This idea that once 24,000 individuals have developed ILPs and are living a lifestyle that they want to live and get a public education is going to be taken away, that they're just magically going to reappear at the schools, is ridiculous, to be perfectly honest with you. So, again, we'll have to see where this goes with the Alaska Supreme Court. But this is absolutely, it was a phenomenal ruling, to say the least. So, with that, I'll take some questions.
All right, first of all, for the folks on the teleconference, if you're listening in two sources and have your phone on hold, please either hang up or take your phone off hold. Thank you. We're going to go back to Iris Samuels with the Anchorage Daily News.
My question is about a bit of a tension that I'm seeing between the letter that was sent out by Commissioner Bishop earlier this week and what you're saying today. It sounds like what you're saying today, that if there isn't a stay in place, really the correspondence programs as they stand they've just been thrown out by this judge. But the commissioner said that people continue using their allotments as they had been. So I guess I'm curious, until there is a stay, if there is a stay, do you think the instruction to families should be stop using your allotment?
No,
Don't spend more money?
no, I don't think so, because we're still trying to figure this thing out. This is unprecedented from a whole host of different viewpoints. So no, we're going to, there's already been a stay asked by the plaintiffs, which we said that's amazing. That's unprecedented. We know why, because I think they got the result they never foresaw. But we're also going to be looking at doing a stay as well. But first, and I don't want to get ahead of myself, but I think there's a couple things we got to work through before that happens, and then I think we're going to ask for it to go to Supreme Court. Do you want to just talk about that?
Yeah, and the technical reason also is that there's no final decision been issued. And so that stay will likely occur before a final decision is issued by the Superior Court. And in that aspect, these things are still live. There's also another technical issue in that the districts aren't part of this litigation. So a Superior Court decision only binds the parties, does not bind the school districts. School districts are not part of this litigation, and so are free to continue and work as they've been doing.
So that's the issue. So the letter is trying to help parents in the immediate now, how to deal with this. And what we're saying is we're preparing for all different possibilities that are going to come out of this. So it's really not a disconnect between us.
All right, we can go back to Aaron Stone, Alaska Public Media.
This is a two-part question, part legal, part policy. So the plaintiffs say that a very simple law, sort of reauthorizing the allotment and ILP programs, could be constitutional if it's specific.
Can I interrupt you for a second? But that's not what we believe was just rendered by the court. Because he talks about there has to be constitutional legal issue dealt with. So if that's the case, then a statute doesn't deal with if there's a constitutional issue, a concern. But go ahead, I'm sorry.
Well, the idea is that the statute could clarify that could basically allow the program to be constitutional if it specifically spells out that public money can't be spent on religious or private.
But he just threw out the whole. The judge threw out basically the whole homeschool correspondence program. It's gone.
The judge had the opportunity to only throw out portions of those statutes. He chose not to, and he ruled them completely unconstitutional. So
you'd be making a statute for something that the court did not say is a remedy.
Okay, that answers my question.
From our perspective. Again, this is very important when you go and you print your stories. We're still trying to figure this out, and the final decision from the Superior Court has not arrived yet. And then we've got to look at what we're going to do with the Supreme Court. So we're just trying to prepare for all possibilities and trying to understand this with everyone else.
Kyle Hopkins with the ADN Republica. I wanted to follow up on a couple questions that came over the phone. Mark Sabatini had asked about the statements you made in 2013 when you were testifying, and the Attorney General said that those have been misunderstood.
Yeah. Want me to clarify that?
Well, you said at the time, and back then you gave that same example of, taking a Latin class from Monroe Catholic, and you said at the time, currently we cannot do that under constitutional language, nor do we have a mechanism under the statute. And you said that within the context of also calling for a constitutional, change to the Constitution. So how are people misunderstanding what you said? What did you mean to say in 2013?
That if you want to do a direct payment to an entity that's not public, a direct payment to underwrite, to help benefit that entity so that kids can go to school there, that was going to be what people call a voucher. You would need a change in the Constitution. Under SB 89, you purchase a course from private and or religious entities in order to underwrite the public outcome, the public education. A voucher is a direct benefit to a school that is private or religious, but non-public, and you would need a constitutional change in that. So, I'm not looking at what you're looking at. I'm not looking at the question. I'm trying to interpret it as you're sending it my way. But we did approach it in two different ways. When the approach on a voucher did not have the support from the legislature, we still want to expand our public education system. We still want to get other possibilities for the public education system. And so we expanded that in the bill to include private and religious educational vendors. So we don't think that's a direct benefit. The plaintiffs want to make the case that it is. A voucher to a private outfit is a direct benefit. It is a direct benefit, and it's different than what we're talking about.
All right, going to the teleconference now, we're going to go to Mark Sabatini with the Juneau Empire.
Thanks. Governor, you said that if this whole thing is upheld, essentially that's it for 24,000 students. And one of the comments I've heard here at the Capitol is folks saying, look, we had correspondence schools and homeschooling before this law went into effect in 2014. If we go back to the system that existed before that, we can find a way to make it work. What are your thoughts about that?
So again, if the interpretation of the Superior Court's ruling implicates the the correspondence and homeschool laws, and in essence, if they are off the books or considered unconstitutional, then you would have to reconstruct this thing through legislation. You can't just fix the religious part of it through legislation. But if the whole thing is wiped out, you would have to reconstruct it, is our understanding. Again, we're working through this as everybody else is, but that is our understanding. And if it were to be upheld by the Supreme Court may very well come up with a totally different concept. They may come up with something totally different. Once that happens, then we'll deal with that and see what we can do. I think most Alaskans don't want the homeschool correspondence programs to go away. I think most Alaskans want the ability to be able to educate their children in a manner that best meets the needs of the kids and the families. But again, we're looking at what was just delivered. This is our interpretation. We are going to wait for the final decision, and then once that happens, we will have discussions and approach this in a manner we think is conducive that helps kids. That's what we're going to do.
For our next, we're going to go to...
Very quick yes/no follow-up. Are you saying that you don't think they'll just go back to the pre-2014 law?
What's his question? What's the question?
Is it going to go back to the pre-2014?
Is what going to go back? I'm not the judge. I have no idea. I don't know what they're going to rule.
All right, Mark, we need to get to other reporters' questions. We're going to move on to Carter
Yeah.
Song with the Fairbanks Daily News Monitor.
Yeah, Mr. Governor, I'm just wondering, do you support public funding going towards religious curriculum, classes, materials, whatever it looks like? And if so, what do you think the benefit of that is?
Do I support the purchasing of coursework from private and religious outfits to underwrite the public education of kids? Yes. Years before that bill was moved by myself, that amendment and Representative Keller's bill, did I support vouchers going directly to private outfits? Yes. And why do I do that? Because I want to make sure that every kid in the state of Alaska has a quality education that meets their needs. I can sit here and talk for hours about the parents and the students I met when I was the administrator for the Mat-Su Central School, the largest school in the state of Alaska currently, which is a homeschool. And every single one of those parents and every single one of those kids had a unique reason why they could not attend a neighborhood school. Many different reasons, too numerous to mention, to be honest with you. And so any and all kids, I believe, are entitled to a great education, a great public education, hopefully, but if not, a great education, period. And so I've always supported. My track record goes back a long time in supporting education in many different methods and many different means.
Our next one is James Brooks with the Alaska Beacon.
Thanks. I wanted to walk through the timing a little bit of the various options to make sure I've got it here, because there's a couple different options for stays, but there's only 30 days left in session. So more likely than not, do you think that there'd be a decision, a need for action after the legislative session is done? And so, if so, what are the options available then? And one of the things I was thinking about in that case was that the pre-2014 system was done via regulation rather than statute, and I didn't know how much you see emergency regulations in that instance as a possibility, or something like a special session, or something else I haven't thought of.
Good question, James. So we're going to prepare for the eventual final ruling from our Alaska Supreme Court. Again, it depends on what they rule on. If they if they have a ruling that's different than what the Superior Court ruled on, we can deal with that in whatever manner the decision is. So again, for example, if the Supreme Court comes out and says all these statutes are null and void, and you either, and again, this is all speculation, but you either do or don't have a homeschool correspondence statutes. We'd have to have discussions with the legislature, probably in a special session, quickly. And that's why we want to start the discussion now on the different options. And again, it's difficult because we don't know what the final decision is. As Treg mentioned, we got a couple days here for the Superior Court to issue their final, and then the Supreme Court. And we hopefully all these things go pretty quickly, and I think everyone wants them to, so that we can get decisions made for kids and families. But we're looking at many different options, and they, like I said, they can range from everything from a constitutional amendment to a potential educational dividend, to a post-secondary type of scholarship, to and if the Supreme Court rules in a manner that it's just a statute change or a regulatory change, we can deal with that. But we won't know until that happens. So we have to be prepared and move quickly.
All right, next we go to Jazz Garrett with
Thank you.
KIY, News in the North.
I don't have a question at this time. Thank you.
All right, thank you. Moving on, we'll go to Becky Moore with the Associated Press.
Governor, can you speak more, a bit more about what you envision as an educational dividend, what that would look like? And when you're talking about post-secondary education, are you talking about looking at the need to reopen what the performance scholarship program looks like?
What was the last part? What scholarship program, Becky?
The performance scholarship?
Yeah, you would have, well, so let's go with that first. One concept would be that you have a K-14 or a K-12 plus scholarship in which individuals are able to get scholarship money, like an allotment is now, and that scholarship money could, if it's not spent every year, can be rolled over and be used for any type of education, blue-collar training, university, K-12, anything to educate the kids. That's one possibility. It's one concept that we would have a discussion with legislators in the Post-Secondary Commission. An educational dividend, we have a PFD that is given to the people of Alaska through well, it was a formula, but through an appropriation right now. Goes to eligible Alaskans, about 650,000 or 600 and some thousand. We would put forth an educational dividend that addresses the needs, if the whole thing was thrown out, addresses the needs for the 24,000 for at least the upcoming year. So it'd be almost a supplemental dividend to deal with the educational needs of those 24,000 for the upcoming year. And then there is going to be other ideas that folks come up with. Again, the ideas are being generated in the absence yet of a final decision by the Supreme Court. That's going to tell what options are really available to us. But we just want to prepare and have the discussions.
All right, next we have Margie Bowman with the Cordova Times. Margie, if you're there and have a question, you can go ahead. All right, moving on, we'll go to Jeff Landfield.
Well, I think we found the source of the annoying beeping. I wanted to ask about the constitutional amendment. Can you hear me?
No. Yes. Can't hear you over the beeping, Jeff. You got to speak louder.
It's very annoying. I don't know who's doing it, but it's about this. Anyways, Governor, when you were in you alluded to this in the legislature trying to do a constitutional amendment. The judge is very clear. If legislature feels this program is important, they should change the Constitution. The language is pretty clear. I asked the House majority and the Senate majority that yesterday, and the House majority seemed somewhat open to it, but 27 votes is a lot, and then the Senate majority seemed totally close to it. So without a constitutional change, aren't all these things like an education dividend or even this program itself, isn't this kind of trying to find a way around the Constitution? I mean, why not really push for the constitutional change, which seems to be the clearest, cleanest way when it's so clear about, direct benefit of private and religious schools?
Yeah, Jeff, I wouldn't dispute the sentiment of the legislators that you discussed this with, but again, we don't know what the final decision is going to be. It could be totally different from what the Superior Court put forth. It could be something we don't even think about. But where I'm going with the educational dividend, the state of Alaska sends out a dividend to Alaskans, and we don't ask them or direct them on how to spend their money. If we find ourselves in a bind, and if the statutes are thrown out, then you have 24,000 kids in limbo, we're going to come up with as many possibilities as we can to assist them with education, at least through the coming year. And one of those possibilities are an educational dividend. Because we don't ask the questions now with the PFD, and we don't ask the questions with what will be an energy dividend. And so we may just have a dividend for 24,000 kids. Now, with that said, I can guarantee you that there are people listening to this phone call right now, especially some of the plaintiffs or their lawyers, that are saying, well, we're going to attack that as well. There's no doubt they will. So in the end, it really comes down to what was the purpose of this case? What was the real purpose of this case? That's the real question that's not being asked. I don't think it will be asked, to be honest with you. I don't think I'll read it anywhere, to be honest with you, on any blog or any newspaper. I don't think people will be asked. What was the real purpose of this case? The real purpose of this case was control. We're up to 24,000 kids now in our homeschools. So there's a worry, a concern by some that the neighborhood schools are going to lose market share. Our public school system is not losing market share. As a matter of fact, our public school system, in some respects, it could be construed as gaining market share. Because now you have kids that were just private school coming into our public school system because we broadened the umbrella in order to address their needs. And so we don't know what the final decision is going to be, and we don't know what the final decision of the Alaska Supreme Court will be. And again, we're going to have to be prepared for a whole multitude of different decisions that could come out. We've got to move fast. But in the end, I'm committed. I'm sure there's a bunch of legislators that are committed to helping these kids. I hope, Jeff, I really do, that when you spoke with legislators, that those that oppose this or oppose that, I hope they weren't just thinking we're going to round them up and shove them into the neighborhood schools, because that's simply not going to work. 24,000 kids, thousands of Alaskans, close to 300 homeschool teachers, public school teachers, vendors, school districts, all will be implicated, all will be impacted. So I think I always believe there's answers and solutions to everything. But I got to tell you, this has been quite the year on education. And unless it's just a discussion on money, there is really no desire by some, including those that filed suit on this homeschool program, to really care about how kids are educated. It's really about money. And to me, that's I think a lot of us, we operate off of a moral imperative to do whatever we can to educate kids. And we'll see where this goes, but we have to be prepared for any outcome.
Our next room is Steve Kirch with Alaska's News Source.
Yeah, hi, Governor. So I was just curious. You talked about some solutions to this. Education credit through the dividend, constitutional amendment. What do you envision the timeline of some of these solutions being? Like, do you want lawmakers to maybe start putting together ideas this legislative session, or next legislative session? What's the timeline on this?
Well, again, we just had a decision. The final decision will be rendered here in a couple days, few days. And then that decision, if it looks like it is going to throw out these statutes, or at least severely impact these statutes that make the current homeschool process, the way it's laid out, unworkable, we have to have several options in anticipation of what the final is going to be. We think it's going to look like the one we have now, the decision we have now. And then we're going to take this to the Supreme Court. We have to, on behalf of the kids and parents of this state. We will do that. And then we have to be prepared for the inevitability of there'll be an outcome there, but what that may look like. So we have to have several options on the table, and we have to have the discussion with the legislature now that when that is rendered, we may end up having a special session to deal with it so that we can give certainty to these kids and these families. So I would anticipate somewhere within those broad parameters, we have an answer and a solution. But again, we have to wait for the final decision of the Superior Court. Then we got to move this to the Alaska Supreme Court. And again, depending upon what the Alaska Supreme Court does, we'll respond to that, and we'll work with legislators on that. And hopefully we come up with a process that continues to cast as wide a net as possible to help our kids, as opposed to working overtime to figure out ways on how to shut some really good programs down.
Our next one is Sean McGuire with the Anchorage Daily News.
Thank you very much. I was wondering, I had just a couple of quick questions to the AG, the Attorney General, if that was possible, just to start. Firstly, I just wanted to ask the Attorney General, would it be possible to share that advice you got from outside counsel that explained that you are no longer in a conflict of interest with that case?
I guess the response to that answer, I'll consider that. It is attorney-client privileged information, and so I'll have to think about that. I don't have a response for you right now.
Okay, and then I was just going to ask as well, the governor has repeatedly said that he thinks a constitutional amendment would need to be considered when looking at this ruling that came down from the Superior Court. I'm looking at the last line of that ruling, and it says, if the legislature believes these expenditures are necessary, then it is up to them to craft constitutional legislation to serve that purpose. Now, the way I read that, I'm not an attorney, but I thought that meant legislation which is constitutional, not necessarily a constitutional amendment. Could you just explain why a constitutional amendment and not a statutory change might be needed?
Well, that statement's in conflict with the rest of the opinion, right? If you look at the rest of the decision, there's no guidance to what would be constitutional and what would be unconstitutional. He simply struck down 2 statutes. So, you know, in a way, drafting something legislative would be just a shot in the dark. You'd just be, you know, because there's no real discussion and real vetting of those concepts. And so I think internally that is in conflict with what actually the decision did.
Could I ask now a question of the governor?
Yeah, sure, go ahead. Yeah, go ahead, Sean.
Okay, Governor. Yeah, thank you. Governor, I've heard some in the education community, if you might want to phrase it that way, suggest that your plan to try and expand charter schools was one to pave the way for private charter schools, and then also there could be more spaces available that parents could use to get reimbursements for private schools. Was that the purpose of why you have wanted to expand charter schools?
So that's, you know, once again, Sean, it's an interesting way to pose a question. I was asked something similar just a while ago. I'm in favor of any and all educational opportunities for kids, any and all, because everybody has a unique situation. The quote educational community that you're quoting, I would imagine that those folks, they are neighborhood school only folks, which will cut off a substantial portion of Alaskan students that want a public education. And so I'm committed to making the public education system work. I'm just not sure if some of those, quote, in the educational, quote, community are as committed as I am to making the public educational system work as opposed just the neighborhood school concept. We have great neighborhood schools, there's no doubt about it, but not everybody's family situation or individual personal situation is a good match with a neighborhood school. So I'll continue to, just like I have for decades, advocate for as much flexibility and choice in our educational systems for our kids and our families. We're done? Okay. Complicated issue, and this decision, I think, for most people was a surprise in its scope and the impact it could make. We're going to wait for the final decision. The plaintiffs have already quickly asked for a stay because I think they were mortified by the outcome. It probably wasn't quite what they wanted. And if you look at the blogs and the texts and so forth, they're scrambling to try and figure this out before it turns into a disaster. We don't want this to turn into a disaster, and my commitment to the people of Alaska and the kids of Alaska, very kids that I once again, I was in charge of the Matsu Central School, and many, many kids across the state of Alaska for a whole host of reasons attend these schools. We're going to do everything we can, and we're going to work with the legislature, but we're going to do everything we can to make sure that your lives aren't turned upside down. And so there's nothing wrong with contacting your legislator and expressing your opinion and your desire to make sure that whatever the outcome is an outcome that's going to work for you and your kids. That's the process. That's the political process. And I often tell people that don't like to get involved in politics, if you don't, you run the risk of becoming a victim. And right now, there is a risk of becoming a victim unless you don't have a discussion, don't send a message to your legislature. Not a nasty communication, just a desire to get this fixed so that your lives aren't turned upside down. We've got to wait for the outcomes from the Superior Court judge's final decision. And we're going to go to the Alaska Supreme Court. There's no doubt about it. But I would ask everybody involved to understand that a one-size-fits-all doesn't work for everybody. It simply doesn't. And I think Alaska has an outstanding public school, homeschool, correspondence school system, as well as the charter school outcomes that we have. And I think all of us should want to expand these public school approaches. But apparently some don't. And that's why we're here today. So to the people of Alaska, and especially those that the 24,000 kids and their families, we're going to work hard with legislators that want to work and come up with solutions. We'll get those prepared. We'll wait for the outcomes. We'll address the court's decisions. And I'm always an optimist that we will end up with a situation that benefits you, the people of Alaska, and not just the members of the, quote, educational establishment. One last thing before I go. It's kind of a one-off, but it was brought to my attention that there was an article written, I think it was in the Beacon, and there was a quote, it has to do with the impediment bill. And the quote that was sent to me was, Alaska lawmakers are considering a proposal for Governor Mike Dunleavy that would further criminalize homelessness. Now, I'm constantly being told that the press is not biased, the press presents facts, the press lets it up to you to decide. That's clearly a slanted statement. The purpose of the impediment bill is this. If you're coming down the Parks Highway and you have a medical emergency with your child in your car and the traffic is backed up 8, 9, 10, 12 cars, you're trying to get to the hospital. And there are 5, 6, 10, 12, doesn't matter how many people that have glued themselves to the highway because they're protesting oil or they're protesting the loss of some species of cockroach, whatever it is. And your child's life is in danger, and God forbid something happens, the purpose of this bill would not only make sure that the criminal penalties apply for that action, but that those individuals could be sued civilly for damages. This has nothing to do with homelessness. But again, that's a clever way of some folks in the journalism world trying to conflate an issue and trying to make an issue where there isn't. This is about folks willingly obstructing your free passage and not paying a price for that if you pay a price. A loved one is sick, somebody gets hurt, loss of job, loss of income. You just have to go on the internet, go to YouTube, and type in protesters stopping traffic. And these are not, we're not talking about a First Amendment issue here. These are not permitted protests we're talking about. We're not talking about doing away with the First Amendment or permitted protests. But no reasonable person is going to say you could sit in the middle of Parks Highway, glue yourself, chain yourself to something, lay down on the road, back traffic up, emergency vehicles, whether there's a fire going on, the police that need to get through. No reasonable person, ACLU excluded, no reasonable person is going to say that's okay. But apparently in an article, this bill is about criminalizing homelessness. Couldn't be further from the truth. But I think most Alaskans, unfortunately, are getting used to the whole idea that you can't always believe what you read. So with that, we'll get back to you more on the educational issues and this homeschool decision by the Superior Court judge. So thanks.